Court calls the case of the People versus James Edward Johnson, case number 22347. Counsel, state your appearance.
This case begins quietly, almost too quietly, but don't let the calm fool you. The moment Judge Simpson calls People versus James Edward Johnson, he's stepping into a legal storm that builds steadily over the next 20 minutes. What starts as a simple OBY plea quickly unravels into chaos involving probation violations, witness tampering allegations, 70 phone calls, and a defendant who just won't stop digging himself deeper. The first few seconds set the tone. Confusion, interruption, and a defendant who already seems out of sync with the courtroom process. Judge Simpson, known for precision and control, senses something is off almost immediately, before the plea even starts. Pay attention to how many times the judge has to clarify, redirect, and re-explain basic procedures. This isn't just a guilty plea. It's the opening chapter to a bigger, more dangerous pattern that we will watch explode in real time. And by the end of this hearing, Judge Simpson makes it brutally clear. James Johnson is his own worst enemy.
Yeah, this is both sides. Jonathan Evans on behalf of People. Good to see you, Your Honor.
Good seeing you, sir.
James Gallagher, Assistant Public Defender on behalf of James Johnson, who's standing to my right. Mr. Johnson, could you please state your name for the court?
James Johnson.
What are we doing? I've called the one that's not the one that's set for jury trial. I've called the one, the malicious destruction of a building. Is that the one?
So this would be the
Right. And that's case 608.
Correct.
All right. What are we doing on that case?
Your Honor, yes, Mr. Johnson appeared to be pleading guilty in that.
Have him sworn.
You solemnly swear to work on the truth, the whole truth, and nothing but yourself. You got it. Yeah, thank you. State your name for the record one time. James Johnson.
Is he pleading to both charges?
No, Your Honor, the offer is he would be pleading to count 1 with count 2 being dismissed. Is that correct?
That's correct, Your Honor.
Mr. Johnson, is this court's understanding that you're going to be pleading guilty to the charge of operating while intoxicated? That is a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. Oh, wait. Are you ready?
Yeah, I'm ready.
Misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. The court could order any community service or rehabilitative treatment the court deems necessary.
This is the legal foundation being laid. Judge Simpson is spelling out the full exposure for the OWI misdemeanor, 93 days in jail, fines, court costs, community service, vehicle immobilization, prosecution fees, and emergency service fees. It sounds like a lot because it is a lot. Judges do this not just to inform, but to make sure the defendant cannot later claim ignorance. And yet, watch Johnson's responses. They're short, muted, and detached. This matters because plea hearings require clear, voluntary, informed decisions. Judges look for hesitation, confusion, or signs the defendant doesn't understand. And the irony? Johnson's real trouble isn't the OE at all. This relatively small misdemeanor becomes the doorway to much bigger consequences later. Probation violations, witness contact issues, and possible new charges. But right here, Judge Simpson is giving Johnson a fair and clean path. Whether he stays on it is another story entirely.
Court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir? And understanding that, you still wish to plead guilty. And to that charge, how do you plead? Now, you understand that by pleading guilty that you'll not have a trial of any kind. Are you on probation? Were you on probation on the date of January 3rd, 2020?
Yes.
All right, this could be considered a violation. Your plea in this case could be considered a violation of your probation. As such, that court that you were on probation to could sentence you to the maximum allowable under those other charges. Do you understand that, sir?
Yes.
Understanding that, you still wish to plead guilty to this charge?
Yes.
Anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily, of your own free will, and because you believe that you're guilty of this offense?
Johnson finally confirms the core requirement of a plea, admitting guilt, because he truly believes he committed the offense. But moments later, the judge begins probing the details: intoxication level, substance ingestion, police stop, arrest procedures, and blood test results. And this is where things subtly shift. Johnson's answers grow uneven. He hesitates. He claims memory gaps. He disputes nothing, yet seems unsure about everything. For an OWI, clarity is essential. The court needs a factual basis to accept a plea. When Johnson fumbles details about why he was stopped or what he consumed, it hints at either foggy recollection or avoidance. And the defense attorney has to step in regarding THC levels, which adds even more uncertainty. This is a key moment for viewers. If Johnson struggles this much just explaining a traffic stop, how will he handle more serious allegations later?
January 3rd, 2020, at the location of International near Gulfside, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you consumed intoxicating or had you ingested a controlled substance? What was that? Was that the only substance? Mr. And
I believe so, Your Honor.
all right. Were you stopped by the police or was there an accident?
Stop.
Do you know why they stopped you? Are you disputing the right of the police to stop you in this instance? Were you ultimately arrested? Were you taken to the hospital for a blood test?
I stipulate there was a blood draw.
What were the results of that blood draw?
Thank you, Your Honor. I believe that it was positive for 8 nanograms of THC and the carboxy as well.
Okay. Mr. Johnson, do you have any reason to dispute those blood test results?
No.
Because we don't have levels, taking into consideration everything on that date and at that time, do you believe that your ability to operate that motor vehicle was substantially impaired or else otherwise that you had a substantial inability to operate that motor vehicle due to your ingestion of drugs?
Sorry, Judge, he was just a question. He was 5 nanograms, so it was in the back for it.
All right. Given his answer to that last question, counsel, have I complied with the court rule and would it be proper to accept the defendant's plea?
People are satisfied, Your Honor.
That's satisfied, Judge.
Court will accept the defendant's plea. Sir?
The judge accepts the plea, but notice his body language and tone. He is not satisfied, even before the next case begins. He repeatedly redirects Johnson, reminding him to face the court, answer clearly, and follow instructions. These are warning signs that Johnson's courtroom behavior is unpredictable. After the plea, sentencing is scheduled and formalities are handled. But the moment the judge switches to the next case, another Johnson case, the entire atmosphere changes. Viewers should pay close attention here. Judges rarely transition from a routine OIY plea into a tense disciplinary lecture. But that is exactly what happens next. The judge's patience is thinning, and his disappointment becomes unmistakable. When Simpson says he had intended to lower Johnson's bond but changed course due to ongoing behavior, that's the first major twist of the hearing.
You need to turn around this way, Mr. Johnson. Understood, sir? Mr. Johnson, am I understood?
Yes.
Court will accept the defendant's plea to count 1. Count 2 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and drug assessment and the victim's impact panel online. Sentencing in this matter will be September 14th, 2022, 9 a.m. Where's your Zoom invite indicates. Bond on that matter will continue. Court does call case of the people versus.
Sorry.
Yes.
Mr. Johnson was wanting to make a request for a bond reduction in regards to this matter. It's a $25,000 cash assurance bond. $25,000 cash bond.
Well, I think I was inclined today, because Mr. Johnson has been asking for that on this case and another case. And I told him that I would deal with them. Part of that understanding was, though, that Mr. Johnson was going to behave himself, and that I weren't going to have any other issues.
Okay.
My concern, however, and I've been informed today, that there are, and I don't even begin to try to understand it, but it relates to the other case, that he's not been doing that. And I tried to, just so that the record is clear, I had tried to, the last conversation Mr. Johnson and I had from the bench, I was trying to implore him to not do certain things, particularly regarding contact, particularly regarding statements that he was alleged to have made.
This is the emotional core of the entire hearing. Judge Simpson isn't just frustrated, he is genuinely disappointed. He explains that he tried to help Johnson, he tried to guide him, he tried to keep him out of worse trouble, and Johnson ignored every warning. This is courtroom drama at its rawest, a judge practically pleading with the defendant to stop self-destructing. But Johnson continued contacting victims, making statements, and violating expectations. This is not small misconduct. This is the kind of behavior that can trigger new charges, impact bond conditions, and influence sentencing. And when a judge feels personally disregarded, consequences escalate fast. Viewers, would you call this defiance, desperation, or just self-sabotage?
And I was trying to tell him to just stop for a moment, because it would have made it a lot easier for me to do what I told him that I would strongly consider, of reducing his bond. I am informed somewhat, I don't know the specific details, but I am informed he did not follow my advice, which, first of all, I'm greatly disappointed that he didn't. And secondly, I was tied by his own conduct. He has virtually tied my hands about what I can do. And he has nobody to blame but himself, quite frankly. I mean, I'm appalled by it. So, I mean, I'll deal with it afterwards, but we're going to have to deal with, I think I'm going to get a motion from the people regarding this next case. So, and it might become clear what I'm talking about. Court does call the case People State of Michigan versus James Johnson. That's case number 22-10347 SN. Counsel, state your appearances on that matter.
Your Honor, Johnson and the deputy.
Jake Young, Assistant Public Defender of the application.
This is set for final settlement conference and jury selection. What are we doing?
Basically, Your Honor, it's come to my attention that in this matter, it's required, the court has required that the victim appear in court if they are not otherwise cooperative at this point in time. I would represent that the complainant witness in this matter is not available or is not here anyway. As this court is, I think, somewhat familiar with the facts and circumstances of the bond conditions, I have drafted a motion for forfeiture by wrongdoing. It's been a bit since I've done it. There is a typographical error that I need to fix on the front cover. I can do that and get that to the court post haste before I leave the building today. But I am asking the court to, I do have Officer Spearhart here from the Pittsfield Township Police Department. I'm prepared to offer that testimony to suggest that the defendant has been contacting the victim.
Here comes the bombshell. The prosecution alleges over 50 phone contacts between Johnson and the victim, despite strict bond conditions forbidding it. This isn't a misunderstanding. This isn't accidental. This is sustained, repeated, intentional contact that can qualify as witness tampering or obstruction of justice. The prosecutor even brings an officer to testify, which shows how serious this is. And note the timing. The last call allegedly happened the morning of a bond violation hearing. That's almost unbelievable. This moment shifts the courtroom from routine scheduling into potential criminal escalation. Johnson's attorney hasn't even seen the motion yet, meaning the defendant has blindsided his own legal team. Judges hate that. Prosecutors seize it, and viewers instantly see the stakes rise. Johnson isn't just facing consequences, he's manufacturing them.
Throughout the course of these proceedings, asked her not to come, to try and make efforts to suggest that she shouldn't be here, or to otherwise say that nothing happened. I've got a phone log contact of over 50 phone contacts that he's attempted to make with her. I believe that the last contact that I have recorded is from August 8th at 9:30 in the morning, which coincides with the violation of bond. I'm not sure what time that happened. I wasn't here, obviously, but the phone records show that contact. So I'm prepared to offer that testimony, or if, obviously Mr. Gallagher is unaware of the motion in its completeness. If he wanted to adjourn this matter and have it set for a special hearing date, we can make ourselves available. I do have motions here if the court wants to take a look at it. But like I said, I would like the opportunity to just correct typographical.
On the front page?
Yeah.
Is it on the substance of the motion, or is it just on the?
Nope. The wrong 8 days to be assigned.
Okay. All right. If you strike through and just put the name on, I'll accept it in that form so we can get this moving.
I'm not familiar with the allegations. I haven't seen the motion. I would request time so I can review that and then respond accordingly.
All right. The first thing that I'll do is I will adjourn this hearing, JFS, to the next day. I have September 14th, 2022 at 1:30. I will also adjourn then the jury selection to September 16th, 2022 at 8:30. How much time did you need? I don't know how we're going to fit all this in. How much time did you need to respond to the motion, Mr. Better? How many hours of phone calls, just ballparking, do you have?
I think it's about 70 phone calls at an average of maybe, we'll just call it, what, typical phone calls are 15 minutes, 20 minutes, so half of that. Some of them go through, some of them don't. So 7.5 times about 70.
That's going to take me quite a bit of time.
You wouldn't be ready by the 31st.
I highly doubt it, Judge.
Yeah. Okay, what I will do, Mr. Gallagher, is I'll set it for September 13th, 2022 at 2 p.m. for the hearing. I would direct that a response from the defendant would have to be filed I can go through it on the weekend. So defendant's response would be due by September 9th.
And Your Honor, Mr. Johnson's informing me that he would like our office to withdraw from this. He believes there's been a breakdown of the attorney client. I'm sorry.
What's the basis on that, Mr. Johnson?
He's not following what asking him to do. We don't have a great communication skills. He's not following what he can do. Like the prosecutor, they said that he did
What? It's due to what?
Do the wrong. all this. They didn't even follow.
He hasn't even filed a response. So what do you mean he's not asking you?
It's a lot between me and him. You know,
I need more specifics than your feelings, Mr. Johnson. And I'm just going to be blunt with you, Mr. Johnson. Mr. Johnson, I'm just going to be blunt with you. I've tried to talk to you through various things. You just don't listen. You think that you're going to do stuff your own way. And I told you that this was going to happen because of those phone calls.
I did not fail to contact him.
What?
I never contacted him.
No, listen, Mr. Johnson, I don't want you to say anything about that. I told you to be careful about that. I went through a long thing so that you didn't get yourself in trouble. Moreover, and you know, Mr. Johnson, I don't know what you're trying to do to yourself. I really don't. Because there are also, and I'm going to be as negative about it as I can, but I'm informed, for security reasons, I'm informed that there are also statements by you that could lead to some additional charges and some very serious charges. I don't understand why you did that to yourself. I for the life of me, I don't get it.
You're right, he's wishing to represent himself, is that correct? No. Okay. He wants our office to withdraw.
I need a written motion as to why. I mean, I'm not gonna just do that. I don't even understand why that's coming up at this point. You represented him just through a plea on that one. We come up to here. It seems to me that what the defendant wants is an immediate response to the forfeiture motion. I'm not even expecting that from you, Mr. Gallagher. And I also have to expect that once receiving the motion, there would have to be an opportunity for you to go through the phone call so you can go through that with Mr. Johnson. So I don't even understand why this motion is being made. So Mr. Johnson wants to file a written motion with the court. I'll look at it and consider it, but he doesn't get his choice of attorneys. So that's how I'm going to do it.
Judge Simpson unleashes one of the strongest judicial warnings you will ever hear. He tells Johnson outright, "You are making every wrong move." He emphasizes that Johnson refuses to listen, sabotages his attorney, and keeps escalating the situation. When the judge says, "That's why you don't have a law degree," it's not sarcasm. It's a blunt acknowledgement that Johnson is acting against his own interests at every turn. The judge repeats that additional serious charges may be coming. He warns that Johnson has taken a small issue and exploded it into a legal disaster. For viewers, the dramatic irony is heavy. Johnson believes he's defending himself, but the judge sees him actively worsening his position every time he speaks or acts.
I mean, I think he's just, to be honest with you, at every step making the wrong move.
Can I ask you a question? Did the prosecution subpoena him to witness?
Pardon?
Or whatever they say she is? Did they subpoena him? Did they go through all the?
Okay, Mr. Johnson, that's why you don't have a law degree. We went through this before. They don't have to do that if what you've done. Do you understand what they're alleging? They're alleging that you interfered. So whether they subpoenaed her or not, or whether they subpoenaed the witness, if I find on these messages that there's been an interference with it, whether she subpoenaed or not, the case will proceed without her. And that's where I think, Mr. Johnson, quite frankly, you need to listen to your attorneys. You've got a very skilled attorney standing next to you. You need to listen to him because, Mr. Johnson, look at me. You're in a lot of trouble that you weren't in when we first came into contact with each other. And I'm going to strongly suggest to you, as I was through those other hearings, that you listen to them so that you don't get yourself in more trouble. Because this, if what is being indicated to the court is even remotely true, Mr. Johnson, okay, it may not be. I don't know. I'm just saying, if it is, you've taken something that is very little and turned it into something that it didn't need to be, and placed me in a position because I thought you had that other matter dismissed. You were dealing with the other thing. I had the bonds here. I'm prepared to release you on conditions. And then you just do stuff that I don't understand. I don't understand you. I really don't. And I don't understand, more importantly, why you're doing this to yourself. So I'll set that. If the defendant wants to file a written motion after talking with you about what this motion really means, if he wants to file a written motion, then I'll consider the written motion, but I'm not going to consider it before then because I think he's just saying stuff. Anything else from either side?
Nothing particularly. I don't think you actually clarified when the response was due.
I said September 9th.
Okay.
This hearing ends on a chaotic note, but the message from Judge Simpson is unmistakable. Johnson began the day with a straightforward OWI plea, something that could have been resolved cleanly. Instead, the judge reveals a pattern of ignored warnings, inappropriate contacts, possible witness tampering, and escalating statements that may trigger new criminal charges. The court sets new dates, orders written motions, and makes it clear Johnson is not in trouble because of the original charge. He is in trouble because of his actions after the charge. Judges take bond violations and witness interference extremely seriously, and Simpson emphasizes that Johnson's behavior has tied the court's hands. The big takeaway for viewers is that courtroom outcomes are often shaped less by the original offense and more by what defendants do afterward. In Johnson's case, every misstep multiplied the consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.